Thank you, and I move Amendment 4 in my name. Minister, during the passage of the Sex Offenders Amendment Act, now after its passage here earlier on, I moved Amendment number 27 to that legislation concerning the harassment of victims for which the perpetrator has already been charged, convicted and served their sentence. Now, the difficulty is, Minister, in terms of sexual offences, we have a situation where someone has gone through the legal system, has been convicted, served their sentence, and when they're released from prison, continue to harass the individual who they had abused and had the conviction was secured on foot of that. And the perpetrator on their release believes that they have a right to continue to harass the individuals. And what the two amendments that I have before the House here this evening are specifically in relation to this. Now, Amendment number 4 is in relation to proceedings to ensure that they remain in camera. So, if the original proceedings associated with the conviction are held within camera, then any proceedings in relation to harassment should also be held in camera. So, you know, if someone was convicted of a sexual offence, naturally enough that is held within camera to protect the identity of the victim. The offender's name and details may not be released for that particular reason. And we want to ensure that if someone has to go before the courts in terms of enacting the harassment legislation, that those proceedings are also held in camera. Now, when I discussed this with the Minister for Justice at committee stage, she made the point to me that, well, look, the vast majority of these will be civil orders. All of those orders will be in camera. But if they're not civil orders, there isn't the provision there that it is held in camera. And what I'm trying to do with this particular amendment is to ensure that we put that particular safety net in place, and I hope you can accept the amendment.
Anyone else on this amendment?
Naughten for introducing the amendment, indeed for raising the matters previously with my colleague Minister McEntee at committee stage. I'm particularly conscious of the challenges faced by victims in prosecutions for harassment and stalking. The trial process, whilst respecting the rights of the accused, must absolutely respect the rights of the victim, and it must try and avoid repeat victimisation, intimidation and, of course, retaliation. Ensuring that the trial process respects the rights of victims will encourage those who have been affected to come forward in the first case. As the Deputy will be aware, there is a general power for the Court to exclude members of the public under Section 20 of the Criminal Justice Victims of Crime Act 2017. In proceedings relating to any offence, this section provides that where it's necessary to prevent such secondary or repeat victimisation, intimidation or retaliation, the public may be excluded from a trial. These criteria are clear and they ensure that the Court has an appropriate power to protect victims. It is important, obviously, to note that Article 34(1) of the Constitution requires justice to be administered in public, except in such special and limited cases as may be prescribed by law. And the implication of this is that particular care is needed in imposing an automatic requirement for in-camera proceedings. So I do believe trying to balance the constitutional obligation in terms of administering justice in public with absolutely the importance of ensuring a victim is not re-victimised, re-traumatised, intimidated or experience retaliation. That's the purpose of the 2017 Act, and I do think in the round that gets the balance right. The new harassment and stalking offences fall within protections applied by Part 3 of the Criminal Evidence Act 1992, and this ensures a number of important safeguards are in place, for example, in respect of giving evidence through a television link. Two further areas are, however, under consideration: a protection against cross-examination and an anonymity provision. And work is continuing on these measures, and I do want to tell the Deputy, and I hope this gets some way towards where he's trying to get to, that I do expect to return to this area in the Shannon, and of course then bring such proposed changes back to the Dáil. I do want to do more in terms of how we bring about protections from cross-examination and the anonymity provision in relation to these offences. Finally, I would note that what we've obviously been discussing, as you predicted I might say, relates to criminal proceedings, and civil order proceedings will always be in private, and these mirror family law proceedings, and there are extensive protections in place for applicants in relation to these. So for those reasons, I don't intend to accept the amendment, but I do hope we can make further progress in the Shannon.
Deputy Naughten.
It's a bit like a curate's egg, Minister. And you are right. There is a general provision in law that the public may be excluded. But the difficulty is here, Minister, that for victims, they are being re-traumatised, having to go back to court in the first place. Whether it's in camera or not, they are being re-traumatised, having to go back in, having to give statements to the Gardaí, provide evidence to the Gardaí, have witnesses and so forth in order to actually take this. Now, there is a huge threshold there that a victim must achieve in order for this to come back before the courts in the first place. And the last thing that they should have to consider is that the state, in bringing that prosecution, that you're relying on whoever the state solicitor is to seek this order from the court at the start of proceedings, and to ensure that that actually happens. And that doubt in itself acts as a barrier for people to come forward. So I've listened to what you've said. I hear what you're saying in relation to the issue of anonymity. I would hope that you will reflect on what I've said here this evening in the Shannon, and I hope that you can come back with a balanced amendment to the House here that will address the concerns that I've raised. Thank you.
I want to thank Deputy Naughten, and I mean, I just want to absolutely assure him that I think this is something everyone in this House can unite behind, wanting to reduce the trauma that a victim can further face when bringing criminal proceedings, to encourage and help people come forward, and indeed trying to support a victim's journey through the criminal justice system is very much at the core of our work and the core of the zero tolerance strategy towards domestic, sexual and gender-based violence. I have obviously outlined to the House that the Criminal Justice Victims of Crime Act 2017 does put in place some protections, and ensuring that the new harassment and stalking offences do fall within the protections applied by Part 3 of the Criminal Evidence Act are also important. I am concerned about that issue around cross-examination, where one person is accused of committing an offence against another. We've had a very good private member's bill from Senator Vincent P. Martin in the Shannon. I want to look at how we can incorporate that, and I also do want to look at anonymity and how we can provide greater anonymity. So I will be bringing forward proposals in the Shannon, which will then obviously come back to the Dáil, and we'll have a chance to further discuss at that stage.
Is the amendment withdrawn? Reluctantly withdrawn. Okay, thank you very much.